Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer. We want to look at a couple rules of evidence, specifically rules 601 and 602. And these have to do with witnesses, and that would include a party, who testify have to have personal knowledge. Okay? And how does this work in a debt collection lawsuit context? So let's take a step back. What are the purposes of the rules of evidence? And this is what Alabama Rule of Evidence 102, and everything I'll be looking at will be the Alabama Rules of Evidence. But it says these rules shall be construed to secure fairness. And then look at the highlighted part, to the end that the truth may be ascertained and proceedings justly determined. So let's just summarize that. It's to make sure that trials are fair and that the truth is reached. So let's look here at the actual rules. So Alabama Rule of Evidence 601, every person is competent to be a witness except as otherwise provided. The reason that this is worded this way is in the past there were certain groups of people who were considered incompetent to testify. So for example, spouses could not testify against each other. But now this is saying the presumption is everybody is competent, is able to testify, unless there's something in the rule. Well, let's look at the very next rule. Rule 602, a witness may not testify to a matter unless evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter. And then that can come from the witness's own testimony. And if you look at the right-hand side of the screen, the comments to the Alabama Rule of Evidence 602. And the comments really sort of flesh out or help explain what's the idea behind this rule. So it says this is unchanged from the Federal Rule of Evidence 602, and it embodies the traditional first-hand knowledge requirement under which a witness is precluded from testifying to a matter about which the witness lacks a first-hand or personal knowledge of the facts. So before the witness can testify, a foundation must be established to indicate the witness was in a position to observe, and not only in a position to observe, but did observe those facts. So let's look at a couple examples. And we'll have a total of 4 examples. And then I'll tell you at the end if you want me to use some other examples maybe that you're dealing with. I'm happy to do that. So these are all in blue highlighting. Number 1, the question would be presented to you at trial. You opened up this credit card account. Okay, whatever it is, Chase, Capital One, Bank of America, whatever it is. Well, let's think about it. 601 says you are competent to testify unless there's a rule of evidence that holds otherwise. Okay, so you should be able to answer this question. Rule 602 says you have to have personal knowledge about this. So the kind of the mental thought process would be, well, do you have personal knowledge of whether you opened the account? So this is not asking if somebody else opened the account or somebody else owes the debt. This is saying you opened this credit card account. Well, you're under oath, okay? And the judge is evaluating your credibility. And I would say that most of us, we are going to know whether or not we opened up a credit card account. So if you're asked that question, you say, I have no idea. Judge is going to be a little skeptical of that unless there's a very good reason for saying that. I mean, you should know whether you opened up a credit card account in your name. So let's look at the second example. You admit that you charged on this account and you owe $3,467.91 in principal, interest, and late charges. Well, again, we start with the foundation. 601 says you're competent unless otherwise. 602 says you have to have personal knowledge. So do you have personal knowledge of the amount of the charges? Now, you may have incurred all those charges, but do you personally know the amount? Probably not. Do you know what the interest rate is from the beginning of the account to the moment that you're there in the courtroom? Or at least through the time that they charged interest, which may be trying to get it there at the courtroom. Well, probably not. Do you know the calculation? Was it 17.97%? and what was the daily balance or the monthly balance, or how was the interest applied? Is that on a monthly basis, a daily basis? Do you know the calculation? If you do, then testify. If you don't, then Rule 602 would say we're not supposed to testify about that. So how about the amount of late charges allowed under the contract? Do you know that? Is it $15 a month? Is it $35? Can you still be charged late charges after the account is charged off? How about interest after the account's charged off? Do you know that under the contract? How about the calculation of the late charges? And take that dollar amount that the question asks you, $3,467.91. And remember, the company suing you has to prove that you owe this amount of money. Well, do you know how that's broken out into principal and interest and late charges? If you do, testify. If you don't, then you would not be in a position where you would have personal knowledge to be able to testify about it. Let's look at two more examples. You admit Midland Funding owns the debt after it bought it from the credit card company, whoever that might be, Chase, Synchrony Bank, whoever. Well, again, 601 says you're competent unless you're not. 602 says you have to have personal knowledge. So here's the question. And remember, debt buyers have to prove that you owe the debt, and that's what these two slides or these two questions on this previous slide were about. So they have to prove that you owe the debt and that they own the debt, because you didn't take out a debt with Midland Funding or Portfolio Recovery or Calvary or anybody else. So you admit Midland Funding owns the debt after it bought it from a credit card company. Do you have personal knowledge of whether Midland Funding bought your old credit card debt? Do you know that that's true? Now, if you do, then you can answer. If you don't, what would you say? What would be the truthful answer to the question, you admit Midland Funding owns the debt after it bought it from the credit card company, and you have no idea if that's true. You have no personal knowledge. What would be the truthful answer? Well, I can tell you what my clients will say, which is, I have no idea. I don't know. Because they don't know. They have no personal knowledge about this. So what about this last question? This affidavit from the original creditor, so again, it could be Chase or Synchrony Bank, whoever your credit card company was, that says we bought the loan and all the records are 100% accurate, proves that Portfolio Recovery bought your debt. Well, again, 601 says you're competent unless you're not. 602 says you have to have personal knowledge. So do you have personal knowledge of who signed the affidavit? Can you even read the name? Who notarized it? Do you have personal knowledge of that? Do you know if the affidavit is legitimate or not legitimate? Did anything happen after the signing of the affidavit? In other words, I've owned several houses in my lifetime. I could say, on this date, I bought this house in Chelsea, Alabama. Well, does that mean I still own it? Well, I actually don't own it because I sold it. Okay, something happened after I bought it. So do you know if anything happened after the signing of this affidavit? And does the purchase agreement contradict the affidavit? So remember, the affidavit says all the records are 100% accurate. But does the purchase agreement down here say, by the way, we make no representation that any of the records are accurate? Well, that would be important to know, wouldn't it? Do you know that? Well, if you don't know this information, then how would you answer this question? And again, all I can tell you is how my clients have answered this in trial, which is say, no, I don't know that this affidavit proves that your company or your client bought the debt. I have no idea. And they say, well, it's right here in black and white. Well, I see there are words on a paper, but I have no idea if this is truthful or not. So, hope you found this helpful. Let me give you a couple of sort of closing thoughts here. If you know somebody that's dealing or maybe about to deal with a debt collection lawsuit and you think this would be helpful, feel free to share it with them. If you are not already subscribed, if you like this video, just click subscribe, and we put out videos every day, and hopefully you will find those just as valuable as this one. And this last thing is sort of my request to you. If you have questions that maybe you've been sued or you're worried about being sued in a debt collection lawsuit, and are there questions you've been asked or that you're worried or concerned about being asked? And you're like, well, how would these be answered? I mean, would I have personal knowledge of that or not? If you want to, put those in a comment. And the ones that I can, I'll do a supplement or a follow-up video to this, and we'll just kind of walk through it. And look, it's a kind of a methodical process, just like we've done on these slides where we say, okay, are we competent? Then do we have personal knowledge? And we just ask ourselves, sort of like every piece of evidence of that question, do I have personal knowledge of this? If I do, then I can answer. The answer might be yes or no. If I don't, then the answer, at least my clients give, is I have no idea. I don't know. Okay. And so feel free to put those in the comments. One thing, because I get a lot of people reaching out to me, calling my office or sending me emails saying, hey, I need to talk to you about this upcoming trial I have in Minneapolis or in Chicago. Here's the thing. I only represent consumers who are sued in Alabama. Okay. Every state is different. You have to look at your own rules of evidence, the way that courts interpret things. So if you're in Alabama, I'm happy to talk to you unless you already have a lawyer. But if you're outside of Alabama, in this context, I really can't talk to you because it just doesn't, first of all, I'm not licensed in your state, and this is a very local thing. It's different if you are coming to me saying, hey, I want to sue Portfolio Recovery. Well, we can sue them anywhere, including in Alabama. In other words, they can be sued in any state in the nation, and that would include Alabama, where I'm licensed. So I can sue them in Alabama, or I can co-counsel with the lawyer in your state. But on these debt collection cases, this is so local. You've got to get with a lawyer in your state who has experience defending these and somebody that's willing and able to answer your questions. And then particularly if you're doing this on your own, you really need to understand the rules of evidence in your state. And keep in mind, that's just a part of preparing yourself for trial. And we have other videos about other things to do. But I hope that you found this helpful, and I will talk to you guys tomorrow. Okay, have a great day. Bye-bye.